good? Yeah. Was it good? Yeah. I was actually on a plane. I was actually in Chicago yesterday, and all these people wearing Cubbies hats. So, did they win?
Yeah.
Wow. Yeah, good start. Good start. All right. So, I'm sorry? Okay. So 3 of you have not picked up your exams yet. I don't even know how that's even possible. Why would you not even want to see your score? Maybe you don't. I don't know. Get them. If you don't, I'll give them back to you. This is for your benefit, not mine. So it's surprising that several of you haven't even bothered picking up your papers yet. I am more or less booked with appointments between my 2 classes till almost the end of April. I still have some, I have 160 students, so one after the other. I think I have like 7 or 8 today alone. So if you still need to see me, email me, but your time may not be for some time until pushing May, which may not be quite as helpful. Okay. Any questions from last week on common law property, the elective share, Sound of Music? She's not even here. Yes, yes, sir.
Actually, what's your opinion on
Well, if you come to my office today, I actually put a sticky note of my diploma, so I've already updated my diploma. I think it's a fitting tribute to Justice Scalia. I'm very excited, and what people don't realize is that the bulk of this money is going towards scholarships. And one of the best ways to improve a school is to attract stronger students. And the way to attract stronger students is with scholarship money. There's not much of a mystery about that. So I'm actually very excited for my alma mater. And I already put a little Antonin Scalia Law School sticky note on my diploma. So I'm already updated. Don't have to pay for a new one. I'm covered. Okay, so let's start. So the last 2 classes we've discussed the concept of common law property. This is the marital property regime in effect in about 40 states, not Texas, but in about 40 states. And under the common law property system, it's possible and indeed permissible for married couples to own property separately. They have to reach some sort of arrangement. They have to both agree to it. But it's quite possible for married couples to hold property separately. Indeed, to have things like the tenancy by the entirety in common law states, which are meant to rebut the notion of separate property. The entire notion of the tenancy by the entirety, as we discussed a week ago, is they own the property jointly. There's no separate interest. In fact, one spouse can't sell it without the other spouse's permission. This is different than a regular joint tenancy where one spouse can sell it and the other one's out of luck, right? The rules for community property states are very different. And this is what you have to deal with in Texas and California and a number of other states. Under the community property rules, everything is presumptively community property. Everything, okay? Even if you have a salary, which you deposit into a bank account in your name only, if you're in a community property state, it will still be treated as community property. The only way to get around the community property regime is for both spouses to sign off and agree to treat the property as separate. Now, if you're the other spouse, you may not have such an incentive to do so, right? You don't necessarily want to give up your share because you want to get half. You don't want it to be separate property. But the key is the presumption. The presumption is that everything is community. Okay? This includes wages. So say if a person earns $1,000 a month, just make the numbers easy. It's presumed that the wife has half of a claim to that money, $500. If the husband then goes and buys some stock certificates with that $1,000, the wife owns half of those stock certificates. Indeed, even in Texas, this is not the rule everywhere, but even in Texas, if, say, the wife has some sort of property she owned from beforehand, okay? The property is separate if it was owned beforehand. However, if there are any rents coming in from the property, any income coming in from the property, those rents are community property. And then the husband would be entitled to half of those rents. The only way to get around this is, again, for both spouses to, in writing, this can't be oral, in writing, must specify. Indeed, the courts have a preponderance of the evidence standard. The spouse must demonstrate by a preponderance of the evidence, which basically means 51%, that they intended to make the property separately. This property is known as transmuting. Transmuting. I'll write the word out here. Kind of like transubstantiation, I guess, but transmuting, right, is where the husband and wife, or husband and husband, whatever happens to be, specify that we are going to be changing the characteristic of a piece of property from community to common law. Okay. So any questions on that? That's just a high-level sketch of the rules of community property. It gets more complicated. That's a high-level sketch. Everyone okay with this so far? Now, I want to oh, yes.
When you said if a spouse acquires property before the marriage is separate, that you're buying it for through inheritance, even the money that comes out of the rent would be part of the community property?
Right. So if a spouse owned a piece of property before the marriage, that's separate. There's no dispute about that. Okay. However, if there's a tenant on the land and rental money is coming in during the marriage, that rental money becomes community marital property. Good. Okay. I want to now repeat something I said last week about common law property. All of these rules that we're about to discuss today only matter in the case of death or divorce. All of these rules about how community property is divided only matters when a spouse dies or there's a divorce. During the marriage, the courts do not get involved with how they divide up their stuff. Courts don't care. If there's allegations of abuse or neglect, there's a different story. But courts do not get involved in the financial custodianship of how a husband and wife distribute property amongst themselves. There's one notable California example that gifts we'll get to in a few minutes. But for the most part, courts don't get involved during the marriage. The reason why this matters is that for most purposes, when the couple's married, it makes no difference whether you're in a community property state or a common law property state. I'll give you an example, right? Imagine you're in a community property state and the husband works and the wife, doesn't. The husband doesn't give the wife any money. Won't give her no. You ever watch I Love Lucy, right? She got an allowance, right? So no allowance is given. The wife can't go to court and demand an allowance. Even though she has a claim to 50% of his earnings, she can't go to court and get an allowance. Now, if there's some sort of abuse, different story, but just there's no obligation to actually share the money in that respect. However, if a divorce is filed for, then the wife can go and claim a 50% share. It only kicks in at divorce, right? So just keep that in mind. Courts do not supervise how spouses manage their affairs during the marriage. It only kicks in after the fact. That make sense for everyone? Okay. The next bit I want to discuss has to do with what happens when there actually is a divorce. And this is very similar to a common law jurisdiction. We discussed that there are a couple of different approaches. One's called an equal distribution, and one is called an equitable distribution. I think virtually every state now has some form of equitable distribution. Texas defines equitable distribution in a very Texas phrase. It's got to be just and right. Sounds like very cowboyish, right? The equitable distribution in Texas must be just and right. What those terms mean, you'll take an entire class on that. But it has to be fair, and that's the underlying guide. of how assets are distributed. So even though it's the case that the husband and wife have a 50-50 share, we don't actually apply an equal distribution. We apply equitable. So it could be the case where one spouse gets 60% and the other gets 40, or maybe one spouse gets 30 and the other gets 70, right? Like whatever the numbers work out. So even after this entire discussion of 50-50, know that in the case of divorce, courts are probably not going to chop it up that way. They'll probably chop it up in some other way for it to be fair. This 50-50 business really only comes into play at death, right? There's no equitable distribution at death. At death, there's a very strict and rigorous set of formulas to decide who gets what and what amount. So to repeat and summarize, all of these rules only matter at death and divorce. And at divorce, you're not getting a 50-50 split. Courts do equitable, not equal. At death, this is where this 50-50% stuff comes in. So try to keep in mind if we're dealing with a death or divorce, there's a difference, right? and property treats those occasions differently. Yes?
So this equitable distribution, is it like the 60-40 or 70-30, whatever they decide? It's more based on needs or based on contribution?
All of the above. And we saw this in the Colorado case. Family courts have significant discretion in fashioning equitable distribution. So it may be based on how much one spouse contributed to the marriage. It may be based on perhaps the other spouse's earning potential. Maybe if they sacrifice the career to be a homemaker, so to speak, right? There's, an almost infinite number of considerations that a trial court, that a family judge could use. And those sorts of determinations are subject to what's called abusive discretion standard, which you may have studied in other classes. So unless the court below totally screwed up, that's going to stay in place. So there's a lot of, uncertainty with these sorts of things because it can go one way or the other. Are there any other questions? Okay. Everyone okay with me so far? So those are the basics of community property. And that probably shouldn't sound too difficult for you so far. Where things get funky, and this is what always trips up students every semester. Excuse me. Where things get funky is when we start talking about joint tenancies and tenancy in commons between husbands and wives in community property estates. Okay, this is where things get funky. I'll explain why. So first off, for the most part, community property estates do not recognize the tenancy by the entirety. It's actually, I've researched this for Texas. It's actually referenced in a few places, but it makes no sense. So I don't think it's ever actually used. But I mean, it's in the statute books, but for your purposes, it doesn't exist, which is good enough for what I need to know. The reason why a tenancy by the entirety doesn't exist in a community property estate is it's redundant. It's not necessary. The entire purpose of the tenancy by the entirety is that the husband and wife own it together and there are no separate interests, right? Well, duh. In Texas, that is the presumption. The presumption is when the husband and wife, for whatever, so I'll just say husband and wife because it saves time, but when two spouses own property together, they have no separate interests. That's the standard. That's like the basic part. So it really makes no sense to have this different estate known as a tenancy by the entirety because that's the normal idea, that the husband and wife take it together with no separate interests. Everyone get that much? Okay. However, we do have tenancy in common, and we do have joint tenancies. The key distinction, as you recall, between the tenancy in common and the joint tenancy is survivorship. The joint tenancy has survivorship. That is when the husband dies, the wife now owns Blackacre in fee simple, right? That's the biggest distinction between the two. But another characteristic of the tenancy, of the joint tenancy, is that each party has a separate interest, right? You recall, with a joint tenancy, party A can sell his share, and that severs the joint tenancy. Party B can sell her share, and that severs the joint tenancy. That concept that the parties have separate shares is inconsistent with the notion of community property. In a community property state, there are no separate shares. There are none. There can't be. So then what happens in a community property state when property is titled as a joint tenancy? It's funky. It's different, okay? And the answer is actually somewhat, there's two possible answers, which drives a law student nuts, but there's two ways this can be done, okay? The first way, the easier way, is that the husband and wife can both agree, we will hold this as a joint tenancy as separate interests, right? If both spouses agree, they can hold their property separately. So they used to have a traditional joint tenancy. That's easy, right? Husband and wife say, you know what? We don't like this community property stuff. We're going to hold our joint tenancy. We have separate interests. That means I can sell my share. You can sell your share. Okay? That's option number one, and that's probably the easier one. Okay? Option number two, and this is where students always get confused with good reason, is they have what I call a quasi-joint tenancy, right? I'll just write it here. Okay? A quasi-joint tenancy. This is not a real thing, but this is what I call it to help you distinguish it. You won't find this in any books, but this is just how I refer to it. The couple effectively has something that looks like a joint tenancy with all the unities and stuff, right? However, neither party can sell their interest by themselves, right? They can't sell their interests. They can't convey their half share. They can't do it alone. So as a consequence, both parties have to turn the key. Both parties have to agree to sale. Okay? I'll get you in a second. So the first attribute of this quasi-joint tenancy, and again, that's not a real term, that's just what I call it so you can, make sense, is that neither party can sell independently. The second key distinction, and this is the one that drives people nuts, is that there can't be a right of survivorship. There cannot be a right of survivorship. Why can there not be a right of survivorship? Because that's premised on there being two different shares. That's premised in the idea that the wife gets a husband's share when she dies. In community property, excuse me, there are no separate shares. They don't exist. So effectively, what happens, okay? Effectively, what happens is that the husband's share passes to the husband's heirs. Okay? The husband's shares passes to his heirs. There is no sort of survivorship. And we'll do an example like this one in a few minutes, and I'll walk you through. But there's no survivorship under these sorts of quasi-joint tenancies. So I'll get you in 1 second. I'm almost done, I promise. Okay. So you recall we did a case. Remember the California case with the walnut groves, where the one spouse wanted to build a boxing ring, right? That was a community property state, and it was a joint tenancy. But it was one of these quasi-joint tenancies where indeed the husband couldn't really have sold the land by himself. So indeed what he was doing when he wrote that lease, as you recall, was a lease of the entire property. There were no separate shares. That may not have been entirely clear to you last week when we did that case. But when the husband leased out for the walnut farm, there were not separate shares. It was for the entirety because they were married in California with a joint tenancy. There was actually one of these quasi-joint tenancies I described. So that may make that case make a little bit more sense. I was talking for way too much, but the lecturing's the only way to get that one through. So patiently waiting. But did you have a question?
I did, but then you couldn't.
See, that happens. It's awesome, right? What was your question, just so I know?
I was before you got to the second point. It sounded a lot like tenancy by the entirety, except then you said that there's no right of survivorship. So.
See, that's why I have to lecture sometimes. I don't like doing it, but occasionally it actually works better. I'll be asking you guys questions for the rest of class, but that's the part I want to plow through. All right, other questions? Okay, so let me to recap, right? If both spouses agree, you can have a traditional joint tenancy. There's nothing wrong with that. Husband and wife think we want to hold this traditional joint tenancy. But the presumption is, unless both parties specifically say that, it's one of these. Again, you're not going to find this word in a book, and it's only for your own edification. But I call it a quasi joint tenancy, and the two characteristics are that both spouses have to convey, and there is no right of survivorship. Okay. There are exceptions, and again, the community property regimes vary by state. So I'm trying to teach you majority rule, whatever you want, but these are the general principles, and I'll point out the Texas nuances when they come around. But this is generally how this joint tenancy exists in a community property state, unless the parties specifically agree otherwise. So you agree otherwise, then you go to the normal rules. Well, this is always in test state, by the way. In virtually everything that I write this year, assume the person's dying in test state. You haven't taken wills yet, so it's mostly unfair. And if the person has a will, they'll have one heir to make it really easy. But the short answer is, even if a person has a will and there's a survivorship right, it goes independent of the will. In other words, in New York, right, a common law state, if there's a joint tenancy and the husband has a will saying all my property goes to my son, not Blackacre, because the survivorship right, the land goes to the wife independent of the will. So all this stuff is irrespective of the will. It makes no difference. But here with this quasi-joint tenancy, because there's no survivorship right, just like with a tenancy in common, right, goes to the heirs, however they're determined, by intestacy or by will, whatever it is. Everyone with me so far? Everyone get that? Okay. Make sure you get that, because if I ask you on the final about a community property state, and there's something involving a joint tenancy, and I don't go out of my way to make clear that the parties agreed for it to be separate, the presumption is it's this quasi-joint tenancy, and then a separate set of rules apply. If the fact pattern is a husband and wife agree saying, yes, we'll have to separate, there's a written document to that effect, you apply the normal rules. But this joint quasi thing is probably what I'm asking about, because there's different sets of rules that apply to them. So make sure you have those cleared up in your head. That's the first complicated topic. There'll be another one in a few minutes. This is the first complicated topic.
If there is no agreement, isn't the presumption that it's just community property?
Yes. The community version is just quasi, right? This is the default community property approach.
Okay.
Right.
So community property and quasi-joint tenancy would be kind of like the same thing?
Community property and what?
And quasi-joint
Yes.
tenancy is the same thing.
Yeah, in a community property state, the default, right, is this quasi. You only go to the traditional one, right, if the parties agree to it.
Just to be sure, I saw something about elective.
We'll get to elective share in a few minutes.
Okay.
Like towards the end of class, we'll get there, I promise. That's actually the second complicated thing of this class. This is the first one, that's the second one. We'll get there in some time. I promise we'll get there. Is your hand up? Go for it. I mean, you can use it. I don't know what you're talking about, but if you talk to anyone else, they won't. It's effectively, this is how joint tenancies work in community property states. I only use the word quasi so you don't get confused with what common law joint tenancy is. It's the same thing. You can have a joint tenancy in Texas, or you can have a joint tenancy in New York. And the word joint tenancy is the same thing, but they have very different meanings based on what state you're in. Make sense? So if you want to call it quasi for me, I'm fine. I know exactly what you're talking about. But the fact is, if it's a joint tenancy in Texas, that, you know, that's how it works. Questions? All right, let's do an example on page 413, please. Where did I finish last time? If I remember. You were the last one? Okay, then I'll go. Oh, so you're next? All right, you want to read page the problem, page 413, please? 413.
Age married, judging, so $5,000 earnings, she deposits in the savings account, name only. Subsequently, he withdraws the $5,000 because of a law taking title and names of them as joint tenants, which then dies the resident notice separate, including property to the son.
Okay. All right, Jesus. So we have a situation, right? And again, it doesn't say, but we're in a community property state. That's the theme of the chapter. So the husband is married. He saves $5,000 as earnings, and he puts in a bank account with his name only. Jesus, does that matter that he puts it in a bank account with his name only? Does it make any difference?
Well, it's community property, so
So does it make a difference if the husband says, oh, I'm going to put this in a bank account that only I open? Does that make any difference whatsoever?
the wife also has access to it.
Well, oh, no. Well, the wife doesn't have access to it. That's actually an important point, okay? I'm glad you said that. You even though the husband puts it in his own bank account, it's still community property. But during the marriage, the wife does not have access to it.
She has like an interest.
She only, when does her interest kick in, though?
When I guess he died.
Or,
Divorce.
exactly. The wife only can touch that bank account at death or divorce. It's a weird aspect of community property. It's just, this beautiful image of the husband and wife jointly own everything together, except during the marriage, the wife can't touch the bank account. Indeed, I think someone asked us last week, if they're coming up to a divorce and the wife is suspicious, the husband will start dumping all of his assets. The wife can actually get a court order saying, hey, tell him not to, empty this bank account. But she on her own can't go there because her name's not in the account.
I just wanted to reiterate. So at death, it's kind of presumed that she's going to get 50%.
We'll get to what happens at death in a few minutes.
But if divorce, she gets whatever is equitable. So
Yes. Yeah, courts don't have equal distribution; they have equitable distributions. They'll chop 50-60, 54, 60-40, 70-30, whatever it happens to be.
It works the same way with rent. So whatever income he makes with rent goes into a separate bank account. She'll only get it.
It's still community property, even if she can't access it. It's this weird concept. Even though the wife can't access it, it's still deemed community property. That's one more confusing aspect. Okay, so you're exactly right. Okay, so I'll go back up top to George. So George, the next sentence says, the husband withdraws $5,000 and buys a piece of property. Okay, taking title in H and W as joint tenants. Okay, so what is the presumption, just based on the facts here, when the husband took the property as joint tenants with his wife? How would you characterize this joint tenancy?
A quasi-joint tenancy.
I think that's right. Why would you say it's quasi?
They didn't agree to it.
They didn't agree to put separate, right? Is that what you meant? Okay, good. So this is really this sort of quasi-joint tenancy. Okay. Now, does it matter that he paid for this with this money from this bank account? Does it make any difference whatsoever that it was from his single bank account?
No, because you said that that's community property. So
Bingo, right? So this is, in every respect, community property. It's paid for with community funds, whatever, okay? So now husband dies, and he leaves all of his property to his son, Okay. Now, George, had this been in New York, common law state, and there was a joint tenancy, what would have happened at the husband's death? Had this been in New York?
There's community property.
New York is common law property.
Joint tenancy, common law would be right survivorship, so it all goes to the wife.
Exactly. So had this been in New York, the wife would have gotten everything. Okay. But now we are in this quasi-joint tenancy for community property, right? Matthew, so because there's no right of survivorship in this quasi-joint tenancy, what happens at the husband's death? What does the wife get?
She gets her share, his share goes to us.
All of his share? Ah, okay. So let's do numbers here. I know lawyers hate math, right? So and then these numbers again only matter at death. So the wife has 50%, and then the husband has 50%, right? That makes sense, Matthew? Okay. How much of the husband's share goes to the wife at death? 50% of what? Which is how much? Do the division. How much? Yes, sir. So what happens is the wife gets 25% from the husband, right? So the wife now has 75%. And again, that's 50% of 50%. The wife gets half of the husband's share at death. The wife now has 50% plus 25 is 75. Everyone get that arithmetic. If I went past you too quickly, we'll send you back to elementary school. But hopefully you can get fractions, right? We are doing with the least common denominator here. So what does, Matthew, just to finish it up, what does the son get in this case? 25% to the son. Exactly right. And the son gets it because he's the heir. In other words, the community property law says at death, the wife gets half of the husband's assets. Before anything goes to the son, the wife gets her share. The wife gets her share. So she gets the quarter. I'm sorry, she gets 25%. And now the son has 25%. So you can see in some respects, community property actually leaves the spouse worse off. Had this been in New York and this had been a joint tenancy, the wife would now have 100%. But under this regime, she only has 75% and has to deal with her stupid son now, right? This is a sort of modified regime. So there are pluses and minuses for being a community property state. And if any of you do any sort of community property law, these are things which you have to tell your clients about. Because the parties could have created a traditional joint tenancy, in which case the wife would have everything, but they didn't. Yeah, Justin.
So the fact that he buys all of his property to his son is pretty irrelevant. His son would have gotten 25%.
Well, had he died in testate without a will?
Well, the problem says that he died devising all his separate community property to his son.
Right. So the key point there is he can only give to his son what's left over after the wife takes her cut. So the wife already took her 25%. The husband only had 25% to pass on to his son at that point.
So if he didn't do this last little sentence of the problem, then what would have happened?
Exactly. Well, if the son was his only heir, right? If the son was his only heir, it'd be exactly the same. But the father had many heirs, then he'd have to chop it up. So it's not exactly the same, but it's pretty close. But the husband can only dispose of half of his estate. The other half goes to the wife as a matter of community property law. Oh, I'm sorry. I didn't see your hand. Thank you. Yeah.
Maybe I'm remembering wrong. Can she force partition by sale or kind?
Not with not in a. Sorry. If the couple's married with this quasi-joint tenancy, they cannot do it for sale.
No, I mean against the son.
Oh, when there's a son, yeah, she can.
Okay.
Because once it becomes mom and the son, it can no longer be this quasi thing. It's a regular, actually a regular tenancy in common at that point. In which case they can force a sale. Yeah. Once the two people are not married anymore, then unless there's some edible stuff going on, that's not going to happen. It's a tenancy in common. I haven't discussed Oedipus in class yet, but I guess it was bound to happen. Oedipus is, of course, the Greek myth of the boy who marries his mother because she was, and then they have kids, and it gets complicated. His mom, was this.
Just to clarify from my own purposes, so the lot, she can't touch it, just like the bank account until he dies.
What do you mean she can't touch it?
Like she has no, it's his property. I mean, even though
No, it's there. No. Well, if it's a joint tenancy, it's their property. They both have to have full access to the entire land, right? But the thing with the bank account, again, this always trips people up. It's in his name, so she doesn't have access to it. Like if she went to the bank and said, "I want to touch that account," they'd be like, "Your name's not in the account." However, she still has a claim to that money. Okay. Now, there's a key exception to this. It's actually, I'll move on. Any other questions in this? I want to go to the next topic.
Yes, in New York, the wife is the one that gets 100%.
Under this quasi-joint tenancy, the wife only gets half of the husband's share. So the wife gets 75%.
No, that's in Texas. In New York.
100%. She gets fee simple. In a common law state with right survivorship, the wife gets fee simple. Make sense? Any other questions on this?
Just to clarify, this has been pretty similar to the elective share document we talked about last time, except that there is.
Very good question, right? So, Jamie, what is the elective share? Remind the class, because I was going to get there later, but I'll do it now.
Where the spouse wants to write off the other spouse from the will, so they leave everything to someone else. The surviving spouse can either elect to keep the will, what's in the will, or take their cut.
Right. Okay. So the elective share, you recall this. So in a common law state, if the husband writes the wife out of his will, the wife can elect to basically take, depending on the numbers, half of whatever the husband had. Jamie, where do you think the common law states got the idea for the elective share from? Bingo. The elective share tries to emulate what exists in a community property state. The elective share tries to copy what community property states have done for centuries. That's where it came from. I mean, it's exactly right. But your intuition was right on, because it's basically a copy, a ripoff, or a copy, if you will. Elective share more later. It gets complicated when you have these migrating couples from one state to another. Those rules get tricky, but we'll get there.
So just rule of thumb, then the forced elective share and community property, basically the same rules.
Well, no. The key fact here, though, is there's a joint tenancy, right? There's a joint tenancy, and that's what allows this sort of half difference thing to happen. If there was a joint tenancy in the common law state, you have right survivorship, and then you don't need the elective share. So it's not exactly the same, but it's modeled on it. We'll get there in 20 minutes, I promise. Okay. So the next topic discusses this management of community property. In the old days, I guess, in community property states, the husband was deemed so-called manager of the property, and that is the husband can make decisions. So even though we said with the community property, one spouse can't convey without the other's consent, well, because the husband was a manager for both of them, he had the authority to then sell everything he wanted without the wife's written permission. It was presumed the wife consented to the husband's sale. That is no longer the case. There may be a couple exceptions, but for the most part, that is no longer the case. Both spouses must consent to transfers or mortgages or anything else. There's actually one not quite funny, but somewhat interesting example in California, which involves gifts. And this was the W.C. Fields example. So in California, with the community property regime, if one spouse gives away presents to someone else with community funds, the other spouse can step in and set aside those gifts. So as you might imagine, because this is California, this often happens with movie stars and celebrities who lavish money on girlfriends and the like. So this is what happened with W.C. Fields, who was a famous movie star back in the 20th century. In this case, Field had this massive estate, $800,000, but he only left about $10,000 to his wife and to his kid. But it turns out that over the years, he had sent nearly $300,000 in gifts to various lady friends, lady friends, as the book describes them. The wife finds out only after his death, and then the wife sues the executor, saying, "Look, those gifts were not made with my consent. Therefore, as community property, I want half of those gifts, right? I want half of whatever sort of money he handed out." Indeed, the wife prevailed. She was able to, and apparently the husband kept very meticulous records of the money he showered on these girls, I guess. So she was able to calculate with some accuracy how much he had paid out to all these girls, and then she was able to collect half of it. Okay. This actually happens fairly commonly in California. Does anyone know the example I'm talking about? Happened fairly recently. Tell us about it, please.
I guess so when it came out that he was a racist and everything else, it came out that he gifted all this, he gave his mistresses a lot of gifts, and then the wife sued to get half of that back.
Okay, good. So Donald Sterling was the owner of the Los Angeles Clippers. There were some recordings made of him saying some pretty racist things. By the way, those recordings were made illegally. It's still unclear how those recordings leaked out, but I mean, those were illegal recordings. California's a two-party state for recording consent, but these are some conversations that were leaked. And it turned out he had this mistress by the name of V. Stiviano. V is just V. It stands for nothing, apparently. I've looked. It's V. And he had given her, and I'm going to read some of these things, a $1.8 million house, a Ferrari, 2 Bentleys, and a Range Rover. And the Range Rover was worth more than $500,000. So he'd given her significant amounts of money. Query whether the wife knew, because apparently she was aware of his infidelities, but she then sued. Right? Again, this is not after divorce or death. This is the California exception, where during the marriage, in fact, they're still alive, they're still married. During the marriage, a spouse can actually seek to set aside gifts made with community funds. So you effectively have Shelly Sterling, the wife, suing this mistress, who had no, as far as I can tell, independent source of income for, a couple $1 million. And I think it's $2 million, whatever it was total. And this actually went to court. And remarkably, the court, not remarkably, but unsurprisingly, the court ruled for Sterling. And they said that Ms. Stiviano was required to hand back the cash value of all these things. Now, good luck collecting on that, I suppose. But property law matters. And so I suppose that the lesson is, if you're an adulterer in California, don't keep any records. I don't know. But you will get caught. All right. So any questions on that? Any questions on that? Yeah, this stuff actually matters. I mean, we're talking millions of dollars in Bentleys and Ferraris and other stuff. So this is not cheap. Any questions on that? Okay. All right, let's move on. The next section discusses mixing community property with separate property. Okay. So this situation usually arises where some piece of property is acquired before the marriage, but the ownership is not finalized until after the marriage. And to give you an easy example, let's say someone buys a piece of property on installments. And say the wife pays for 1/3 of the installments before the marriage, and the remaining 2/3 of the installments after the marriage. Now, It's certainly true. I'm going to ask. Hold on, James. So when the wife is paying the first third before the marriage, where is that money coming from? What kind of money is that before they're married? Yeah, it's separate. Now, after the marriage, she's paying the other 2/3. What money is she using to pay that off? Okay, so here comes a problem. The property was paid for partially by her separate funds and partially by her community funds, right? So there's different sets of rules, or 3 sets of rules, which the book discusses. Kaylee, Anna, do you want to tell me about the inception rule, which is the rule that's actually applied deep in the heart of Texas?
So it says that it's the time your wife signed the contract.
Good. What the inception rule states is that the characteristic of the property is determined when the contract is signed. The characteristics of the property are determined when the contract is signed. Generally speaking, property does not change its characteristics. Okay, generally speaking, if it's deemed separate property, it stays that way. And the Texas rule, the inception rule, tries to reflect that. If the wife bought it on the presumption that it's separate, it remains separate. Okay, that one's an easy enough rule to apply. If you notice, the Texas one's usually easier. The other ones are more complicated. All right, so Christian, tell me about this time of vesting rule. What does that say? No, not the pro rata, the time of vesting rule.
Title does not pass the wife until all the installments are paid. Hence the house is community property.
Okay, good. What this time of vesting rule says is it doesn't matter how the property was characterized when you first got it. What matters is when you finish paying it off. So until all the installments are paid off, okay, the wife doesn't actually own it. It's this weird theory, right? You don't own it until you paid it off. So therefore, it's community property.
Can you repeat that again? I'm sorry. That doesn't matter how the property was. What again?
The wife doesn't actually own it until she makes the last payment. Therefore, it's deemed community property, right? Because there's some community money going into there, it's deemed in that respect as community property.
So when the payments are all paid off,
It's still community property, right? In other words, the second they got married, because she hadn't paid it off, it's now considered community property.
So I'm married, and my first wife and I both put an equal amount to pay off our 30-year mortgage. We get divorced, I get a new wife, and I finish paying off my mortgage. You're saying the first wife would have no right to it because it's not community property yet?
Say your example. I think I missed your example.
So if I have like one wife and we're paying on a mortgage together, but it hasn't been finished being paid off before we divorce.
Well, when you divorce, though, there's a distribution of assets.
Okay, so
and you'd have to either sell the house or do something with the house. I mean, after divorce, you decide how those assets are chopped up. And generally speaking, before you get a second wife, you have to divorce the first one. It's a general rule of law, but not equally applied to. I saw a hand somewhere over there. We were gonna ask the bigamy question too, or?
No, mine's actually about so if the wife purchases, or so a woman purchases a home, pays a third, that gets married, pays another third off, and then divorce. Would it be?
Well, under the inception rule, like we have in Texas, it's her separate property. Right. But under this time of vesting rule, it becomes. Oh, I see what you're saying. I think if at the time of the divorce she still hadn't paid it off, it would probably go back to being separate. But the other spouse may seek a claim for the money that they put in, which is actually the pro rata one is seeking to address. You want to actually tell me about this third one, this pro rata approach?
Yeah, instead of the community payment, they buy in the rata share of it.
Yeah, right. So this is effectively what Hunter was asking about a minute ago, and this is why California always has the most complicated one, but usually the most fair one. So they effectively try and see how much money was put in during the single time, bachelorhood, right? How much was put in during marriage, and then they can divvy it up in that respect. So imagine if it's a 30-year mortgage, the wife paid off 1 year as an unmarried person, and then 29 years as a married person. Well, then this can be basically all community property with perhaps a small share. Hello.
Sorry about that.
That's okay. No clue. Yeah.
So the risk that the other spouse is taking on with the debt, is that different?
Well, here's what's interesting. The spouse doesn't need to put his or her name on the mortgage or the installment contract because the money being paid into it is community funds. That's what makes it community. So in fact, there's no risk, right? The spouse doesn't need to put his name or her name on the installment contract or the mortgage. It becomes community property by virtue of the fact that community money is being paid into this debt. That make sense?
So it's like a risk.
I guess. So if you want to get married, whatever, but yeah.
Through the inception rule, if, let's say before you get married, you pay your third, and then during your marriage, you're paying the other 2/3.
Right.
Will creditors be able to seek the property from the person who is like during the inception? In other words, like if the
So the creditor issue is complicated by the rules of joint tenancy. So it's further complicated. You're too complicated. Don't worry about it. I understand your question, but the issue with creditors and community property estates gets very complicated, and it's a little bit further than I want to go. Okay, everyone get that? Okay. Let's do on page 416, please, the first question. This may highlight some of the issues which Hunter and Elizabeth asked about a minute ago. Okay. You want to read it for me, please, Brent?
During marriage, H takes out a $50,000 life insurance policy on his wife, including out of his earnings. The name beneficiary is H's son X. At H's death, he is entitled to $50,000. Suppose that H has taken.
Okay, stop right there. Okay, very good. So it says during marriage, the husband takes out an insurance policy on his life, paying premiums out of his earnings. Now, Brent, again, we're in a community property state. Are those his earnings?
No, they're shared.
Okay. So whenever you see like he's paying money from his earnings, in your head, substitute, no, that's not your money, it's community property. So it says the beneficiary is the son S. Okay. Now, Brent, at the husband's death, how is that money then chopped up?
Half of that would go to the wife, and then the other half would go to
Good. And then just put this in dollars and cents. How much does the wife get?
$25,000.
And then how much does the son get? Good. Wife gets 25, husband gets 25. Because community money was spent to create this insurance policy, the wife gets her half before the son touches anything. Okay? Everyone get that? That's the easy one. The next sentence, it gets a little bit more complicated. So you want to read, let's see, there's, Caitlin, you want to read the next sentence, please? Suppose.
Suppose that H has taken out the policy before marriage, and that $3,000 in premiums have been paid before marriage, and $7,000 in premiums have been paid after marriage from community funds. At H's death, who is entitled to $50,000?
Okay, so now it gets complicated. This is what a couple of you were asking about a few minutes ago. The husband took the policy out early. $3,000 were paid in. He gets married, and then $7,000 was paid in. So the $3,000 were separate funds. Caitlin, what about the $7,000? How would we characterize that money? After he's married, how do we characterize the money he put into this premium? I'm sorry? Were those his earnings alone? That's those $7,000. So what are they? Exactly, right? So the $7,000 paid in after the marriage and community. So let's walk through. This is indeed a Texas case. You can see the citation over there. Let's walk through how this turns out under these different rules. So, Caitlin, how would this case turn out in Texas? What rules do we apply here? We apply the inception rule, right? How does this turn out under the inception rule?
If you bought it before marriage, it's yours.
Okay, so it gets a little trickier. So you're right. Under the inception rule, right, the policy is H's separate property. H, husband. Under the inception rule, the policy is the husband's separate property. But there's a wrinkle, okay? There's a wrinkle. Zachary, what do we make then of the $7,000 that were put in from the community funds? How do we treat that $7,000? That $7,000 was community. There's no dispute about that whatsoever. How do we make sense of that? Yeah. What happens to that $7,000 that the wife and the husband jointly paid in? I'm asking you. Does that just disappear? Is that $7,000 gone from the wife? She'll never get it back?
The policy itself would be owned under his separate property.
But what does the wife get at his death? It's tricky. It was community funds put into this.
Did she receive $7,000 back?
How much? All the $7,000?
No, $3,500.
Bingo. Follow me here, right? The $7,000 paid in was community property. Okay, the $7,000 paid in was community property. That doesn't lose its characterization as community because it was this separate insurance policy. It was community property. So what happens is the wife gets half of that $7,000. The wife gets $3,500. So if you imagine, the wife gets $3,500 and the son gets $46,500. Right? You basically take off $3,500 from the insurance policy because it's half of what she paid in. So the benefit of the community property is that you preserve that amount for the wife to take half back out. This is the same thing as vis civiano, right? The husband can't spend money on something without the wife getting half of it. Even if it's something that created before the marriage, she still gets half of the money that was put in for the community. Everyone get that? Yes, Justin.
I guess I'm confused. Would the wife not get 75% of the 7,000?
No, she gets half of the 7,000.
Okay, and the son gets the other half?
Yes.
But how's that different than like the example before where the son only gets 50% of 50%?
The reason why it's a good question. The reason why it's different is we're talking here about cash, and to start, the $7,000 was really not his or hers; it was their cash together. So she's really claiming her own half share in the money. Good question, though. So what ends up happening is the wife gets half of the community money that was put back out.
Can you say maybe a little bit more about the difference? Because I was pondering that too. Because the last one was money also. I didn't,
Wasn't it those? Oh, the bank account, right? Oh, I thought it was a property question. Okay, so the issue. Okay, let me restate the question so everyone understands. In the example we did before, the wife got half. I'm sorry, the wife had her half of the property, and then she was able to get half of the husband's half. Okay. But the issue here is that these were $7,000 paid in from their joint account. It was jointly owned, right? This was joint community property. The wife then takes half of what was paid in, not half of the husband's half. This wasn't any sort of separate interest involved with separate pieces of property or separate interests. Okay, makes sense? I think that was that with the quasi-joint tenancy. Again, the rules there are kind of different. Here, it's just straight up cash, so you get half of it back, not half of the half. Questions on this? Okay. Catherine, I'm sorry, Catherine. So let's consider this if it was California, the so-called pro rata approach. How do you think this would turn out in that regime?
I would say it would be community because 7,000 is more than 3,000. Isn't it kind of buy-in?
Right. So how would this work under the pro rata approach?
The 7,000 units would buy in to the share.
So what percentage was paid with separate funds and what percentage was paid with community funds? So the total of $10,000 paid in, right? What percentage was separate? What percentage was community?
30% was separate, 70%.
Good. Okay, and I'll do the math for you because people hate doing this, right? So the wife, the community property was worth 70%. 70% of 50,000 is 35,000. Okay. $35,000 of that policy is considered community. Okay, so Catherine, finish it up. Then how much of that 35,000 does the wife get? Half. 17 and a half. Yeah. I know. It's okay. So the community value is worth 35,000. The wife gets half of that 17,500, and then the son will get the rest. Okay.
Under the inception rule, you know how technically the wife did not own the policy. Does that mean she's not covered by it either?
Well, she's not a beneficiary in the policy, right? But the operation of law in Texas steps in and says the wife gets a share anyway. In other words, because community funds, because these $7,000 in community funds were put in, the wife then gets half of that back. But she's not actually a beneficiary, but she's getting her share returned from the community policy. Yeah.
Just to clarify, so then in that pro rata rule, the community property is 70%, that's $35,000, but the wife only gets half of that.
Yeah.
She's getting 50%.
Yeah, she's getting half of the community value. It's always going to be half the community value. Tricky, right? Everyone get this so far? All right, let's move to the next topic, the so-called migrating couples. In this regard, you as Texas law students are at something of an advantage over property lawyers in other states. And the reason why is that you're actually aware of all these difficult community property issues. I never learned about these things, and most law students don't in common law states. This matters because couples move. Lots of couples, move to retire in Austin or in California or in some other state, right? It happens. And if a migrating couple is not careful with how they handle their property, at death or divorce, one spouse can really get the short end of the stick. So the first principle to remember is that the characterization of property, whether it's common law or community, is determined when property is acquired. By the way, I'm not talking here about bank accounts. I'm talking about like property stuff. This is not inception. It's different. So the book gives an example. Someone buys a horse, in New York. The horse is common law property. She buys it with her separate money. Fine. They bring the horse down to Texas. The horse does not change its characteristics. Okay, the horse remains separate property of the wife. Okay. The flip side is true. If a couple in Texas buys a horse, it's community property. If they move to New York with the horse remains community property. Indeed, I think almost every state has enacted a of law that effectively says we will treat property based on how it was characterized when it was acquired. Okay? So that's simple enough. Yeah, Hunter.
When you're purchasing property, since there would be a contract, you choose essentially what law is governing the purchase of property?
What state are you in? What are you asking?
Well, let's say you want to buy a property in Texas, but you want it to be governed by the laws of Delaware.
You can't do that.
You can't do that?
What you can do, so property, the law that governs a piece of property is what's called the law of the situs. Oh, so I'll give you a little conflict of law lesson. I encourage you won't listen to me, to take a class called conflicts of law. It's offered like only once, like 15 people take it. But it's called conflicts of law. And what Hunter's actually asking about is what happens, okay? You guys studied Erie Railroad. I'm sure it still makes you burn in your mind, right? So you have a car accident, right? You have a person from Pennsylvania get into a car accident with a person from Delaware in New York. Whose law do you apply? Well, generally speaking, you apply the law of where the accident occurred. You apply the law of New York, even though this guy's Pennsylvania and this guy's from New Jersey, whatever it is. What happens if you make a contract and the person making the contract, one person's from New York, the other person's from New Jersey, they sign the contract in Delaware and it's going to be executed in New Jersey? Whose law do you apply? These are actually very complicated rules governing this. Fortunately for you, for property, the laws are easy. It's called law of the situs, which basically means you apply the law of where the property is located. Really easy. So if the property is in Texas, you apply Texas law. If the property is in Delaware, you apply Delaware law. Now, to answer Hunter's question more fully, if a husband and wife buy a piece of property in Texas, and they say, we want to treat this as separate property under the laws of Texas, they can do that. There's nothing stopping them. However, if you buy a piece of property in New York and you say, we want to treat this as community property, no go. New York doesn't have such laws. So the only way to actually have community property created is to acquire it in a community property state. You can't, I mean, you can make a tenancy by the entirety, I suppose, which mirrors that, but you can't actually make it community property. Okay.
Is it where the property is located or the property is acquired?
Located. I mean, well, property doesn't move. It's in one place. I mean, if we're talking about personal property, that stuff moves around. I should specify this is real property. This is actually land, right? You know, Blackacre will be in Texas forever. It cannot move. It's stuck in place. You can't, you know, airlift it, you know, and drop it in another city. That doesn't work. That's not how this stuff goes. Okay. Now, let's go on to the thing I think Cody asked me about a half an hour ago, which is the elective share. Go back up top to Jackie. Jackie, remind us, what is the elective share? What is the forced elective share? Exactly right. So the forced elective share says, even if the husband disinherits the wife can claim a certain percentage, 40%, 50%, whatever it is by statute. Okay. Now, I said this last time, I'll say it again. The forced elective share only exists in common law states. There is no forced elective share in Texas. I promise you, on the exam, if asked about community property, a quarter of you will write about the forced elective share. You'll be wrong. There is no forced elective share. Do not tell me about a forced elective share in Texas. It does not exist. I warned you. You'll do it anyway. I always warn you. It doesn't matter. But here's where the problem arises. Okay? Here's where the problem arises. Let's say a couple marry in Ohio, right? Actually, let's go on to the 417. This question, I think, does it. This does it pretty well. You want to read it for us, please, Ross, on page 417, the first one?
H and W married live in Ohio. H is coming during the marriage. H accumulates personal property worth $500,000. Under Ohio law, W has H's death, elective share of one half of H's property. After retirement, H and W move to Texas, community property state. H dies, leaving a will dividing all the property to his daughter by marriage. Texas does not have an elective share statute. So W is
Okay, so here's the situation. Husband and wife live in Ohio. The presumption is the husband's earning all of this money, and then the husband has $500,000. Now, it's not clear from the question, but presumably that's separate property, right? The husband keeps it in his own bank account. And in Ohio, you can do this, right? So Ross, what is the wife thinking while they're living in Ohio? Is she particularly concerned the fact that the husband keeps it in a separate account? Do you think that bothers her when they're living in Ohio? Why would it not bother her? Yeah. The presumption is even if he dies, he can't write her out the will. Why? The elective share means you can go in and take half of that $250. Now, Amber, I'm sorry, Alyssa. In the next case, it says they moved to Texas. Now, all the property they acquired was in Ohio. Was that community or common law property? Okay. Does the fact the couple moves from one state to another change the characterization of the property? Okay. So what happens when she gets to Texas and her husband dies and writes a will disinheriting her? What happens to her? Can she claim elective share? She can't claim elective share. So what happens to her property? Doesn't she get half? That's a trick question. Half of what? No. What does the wife get half of? Be very careful here. Does she get half of all the property? She gets half of what? You're really close. What do you get half of in Texas? What kind of property do you get half of? Want to take a stab, Jake? What do you get half of? Do you get half of all the property? Think of the Colorado case with the diploma, right? What did the wife get half of? Did she get half of the diploma? What did she get half of? What there's a word for the type of property that the wife gets half of? Remember it, Timothy? Bingo. That's what I'm looking for. That was it. The word is community. It's like Sesame Street. The word of the day is community, right? This class is brought to you by the word community. She gets half the community property, right? So I'll come back to Alyssa. Was the money in Ohio that was common law considered community? It was not. So would she get half of this common law property? Exactly right. She does not get half of the common law property because it's not community marital property. The property does not change its characterization when they move. So the wife does not get half of the $500,000. I'll get you a second. And she gets no elective share. And because Texas law governs, the wife gets zero. The wife, what's that? Half of zero is zero, right? She gets zero. I think your hand was up first. You only get half of community property, right? Is there any community property in this case? There's none. How was all the Ohio property characterized? No, I'm asking. You're not done yet. How was all the Ohio property characterized? It's not community. What is it? Common law, right? Separate common law. So what happens if there's 0 community property and the wife takes half of that? What does she get? Bingo. You get 0% at all. And there is no elective share in Texas, so the wife gets zip.
If they didn't move to Texas to retire and they actually went there to continue working, all the property they acquire in Texas.
The newly acquired property becomes community. However, the example is written like this because usually people go to retire, they're not earning income anymore.
Yeah.
They're living off pensions, they're living off Social Security, retirement, whatever it is, they're not making new income. That's why this problem is particularly pernicious for retiring couples.
So was this because he died in Texas or because they were domiciled?
It wouldn't matter if they're domiciled in Texas and he died. When you die, right, your estate goes through the probate process of your domicile. Their domicile was in Texas. So even if he had died in a plane crash, somewhere else, and they brought his body back, they would go through the probate process in Texas.
What if only he had moved to Texas and she had remained in
The married couple's not living together?
Yeah.
Were they like separated, or they just didn't want to live with each other anymore?
I don't know.
I mean, there's actually a doctrine called abandonment in family law, where if one spouse leaves the other, they can actually petition for divorce through abandonment. But I suppose if they're consensually living apart, maybe he has a job there, they have a job there. I think you would still apply the law of the domicile of the husband because that's where he died. I saw another hand somewhere. Yeah.
I've been wondering this whole class. So, like, he has $500,000 in a separate account. Well, let's say then they move to Texas and put $10,000 in, but they're also kind of withdrawing money. And so,
Right. So, what point does it become commingled? Is that your question?
Well, like, which dollar is community? How do you decide?
So let me answer your question 2 ways. If the husband's trying to keep this money away from his wife, he doesn't touch the account. If the husband doesn't really think about these things and they start, depositing joint community earnings together, you actually commingle it and it becomes community property. So, yeah, right. It's like if you put, like Robert Nozick said, put, 1 drop of tomato soup in the ocean, does the entire, ocean become tomato soup, right? But if you put $1 community property, the account becomes community. Yeah. I think it says personal property, so it's not real property. They use the example, a bank account, right? Bank account. They use the example of a bank account because you can actually move a bank account, right? Imagine if you have a Bank of America account. You have a branch in Cleveland. You have a branch in Houston. Your account number is still the same. It's just where you're living it changes. All right. So questions on this? All right. I'll mention briefly the stuff about common law marriage. I always get questions about this because Texas, but historically it was conceivable to hold yourself out as married, and even if you didn't have a marriage license, you can actually receive the recognition of marriage. Where this actually matters is when you have 2 people living together for a very long time, and one person thinks they're married or they're acting as if they're married, and the other one doesn't. Then they break up. And then one of the parties tries to seek an equitable distribution of assets. And the other guy says, wait a minute, I never got married. So there's actually a story about a year or 2 ago involving the guy on Sesame Street. Who did he play? Gordon, right? The Sesame Street character, Gordon. And he was living with a woman for about 40 years. And they had 4 children together. They were never married, but they were together for 4 decades. And then the husband engaged in some sort of adultery, and he had a child with someone else, and they split up. So the wife tried to say, "Hey, we were common law married, and I want some money." And then the husband said, "Oh, I never thought we were married. I thought we were just living together and having children and doing sorts of things." And the courts are pretty strict upon this, so she didn't get anything because they were never married, and he insisted we never held ourselves out as marriage. In fact, in today's society where there's really no stigma of not being married, the argument for this common law marriage becomes much weaker This doctrine was created because at a time it was difficult to travel to the county seat and get a marriage license, and if you're married in the church, it was good enough for most people. Okay. The chapter also has some stuff on same-sex marriage, and I suppose I should stop assigning it, but at the present moment after a Obergefell, it really makes no meaningful difference. Every state has now applied whatever property laws affected husband-wife to now husband-husband and wife-and-wife. But perhaps it's a vestige of the old textbook. It'll be updated in the next go-round. All right, so any questions on that? All right, so to summarize, right, this is our last dalliance with family law. When you're approaching one of these questions, you have to make sure you're applying the right rules, right? So if you're in a common law state, you have to pay very close attention to whether the parties keep the things separate or they keep their things together. And if it's together, you have to look in terms of the joint and the entirety. And always with a common law property, remember the elective share. That's what comes in after death. In contrast, when you're dealing with a community property state like Texas, for example, you have to pay very close attention to whether they go out of their way to separate the property. If it's not, think about the joint tenancy, the so-called quasi-joint tenancy, and how upon death the other spouse receives half of the deceased share. Questions? No? All right. Have a wonderful day. I will see you all on Thursday. Thank you very much.